Hello dear students, today we are going to discuss the Specific Relief Act 1963. Before going through this topic, first let's have a look on its objectives. First, basis of Specific Relief Act 1963. Second, Specific Relief Act 1963 is not exhaustive. Third, recovering possession of property under the Specific Relief Act 1963. Fourth, circumstances when the defendant is bound to deliver the possession. The Specific Relief Act 1963 was enacted as a result of the report of 9th Law Commission of India, submitted in 1951 to the Government of India. A number of recommendations were put forward in the 9th Law Commission report for improving the provisions of Specific Relief Act 1877, following which the Specific Relief Act of 1963 was passed. Now, dear students, we will discuss the basis of the Specific Relief Act 1963. The Specific Relief Act 1963 is based on the rules and practice of the English law in relation to the doctrine of specific performance. So, even though the rights and liabilities of concerned parties and the powers of courts in India in the matter of granting specific relief are governed by the Specific Relief Act, yet as the Act has been founded on English law. Wherever the Act does not deal specifically with any matter, it is permissible to refer to English law. However, if there is an express divergence, then the Act will be strictly adhered to, whatever be the English law. Now, we will discuss the Specific Relief Act 1963 is not exhaustive. The Specific Relief Act 1963 is an act to define and amend the law relating to certain kinds of specific relief, and as the preamble to the Act itself indicates, the Act is not exhaustive and certain specific remedies can be granted under other statuses also. This has been held by the Honorable Supreme Court in Hungerford Investment Trust Limited versus Haridas Mundra and others. The Specific Relief Act 1963 is not an exhaustive enactment. It does not consolidate the whole law on the subject. As the preamble would indicate, it is an act to define and amend the law relating to certain kinds of specific relief. It does not purport to lay down the law relating to specific relief in all its ramifications. Although a matter on which the Act defines the law might generally be exhaustive, the Act as a whole cannot be considered as exhaustive of the whole branch of law of specific performance. Now, let's move to the other important topic, which is the spectrum of reliefs allowed by the Specific Relief Act 1963. The spectrum of reliefs allowed by this Act falls under the following heads. First, recovery of possession of property. The first chapter of the Specific Relief Act 1963 discusses the recovery of possession of property. This chapter discusses the remedies available to those who have been dispossessed of their property without their consent and otherwise than in the due course of law. Second, specific performance of contract. The only way the Indian Contract Act can enforce a contract is by awarding compensation to the injured party. Compensation, however, does not always serve the economic purpose of a contract. Sometimes there is need for a remedy which would compel a defaulting party to actually perform his contract. This important function is undertaken by the second chapter of the Specific Relief Act. Third, rectification and cancellation of instruments and rescission of contracts. Chapter 3 helps parties who want to have their mistakenly executed documents rectified. Sometimes, instruments framed by the contracting parties fail to express the intentions of the parties. The rectification of such instruments become necessary. Also, there is a category of contracts which for some reason or the other, for example, lack of free consent, are voidable at the option of the party whose consent was not free. Such a party has a right to have the contract rescinded under Chapter 4 of the Specific Relief Act. Also, the cancellation of documents already executed which are later on found to be void or become void because of one reason or the other is covered by this Act under Chapter 5. Fourth, declaratory relief. Another area where the Specific Relief Act 1963 is of great relevance is that of declaratory relief. Sometimes it happens that a person has a right in some property or has an entitlement to some character but is being denied his right. Chapter 6 of the Specific Relief Act 1963 allows such an aggrieved party to proceed against anyone who is denying or is interested in denying him his right. In such matters, the court, through a declaratory decree, issues a general declaration as to the entitlement of the aggrieved party to such rights. Fifth, preventive relief. In some cases, the nature of the contract is such that it does not allow for specific performance, nor can damage likely serve any purpose. In such cases, the court can restrain the party which threatens the breach of contract to the limit to which it is possible to do so. Preventive relief is granted by a court by issuing an order called injunction, directing the concerned party not to do a particular act or directing them to do a particular act. The provisions for such relief are granted under Chapter 7 of the Specific Relief Act 1963. Now, moving to another topic, recovering possession of property under the Specific Relief Act 1963. In this chapter, the following topics shall be looked into and discussed. First, recovery of specific immovable property under Section 5 of the Specific Relief Act 1963. Second, suits by persons dispossessed of immovable property under Section 6 of the Specific Relief Act 1963. Third, recovery of specific movable property under Section 7 of the Specific Relief Act 1963. Fourth, liability to deliver possession to person entitled under Section 8 of the Specific Relief Act 1963. Now, first we will discuss recovery of specific immovable property under Section 5 of the Specific Relief Act 1963. This section deals with action for recovery of possession of specific immovable property based on title. Section 5 of the Specific Relief Act 1963 reads as, "A person entitled to the possession of specific immovable property may recover it in the manner provided by the Code of Civil Procedure 1908. The idea behind this section is that whoever proves a better title is a person entitled to possession. A title may be on the basis of ownership or possession. It is a principle of law that a person who has been in long and continuous possession of an immovable property can protect the same by seeking an injunction against any person in the world other than the true owner. Now, we will discuss what immovable property refers to. The expression immovable property is defined neither by the Specific Relief Act 1963 nor by the Indian Contract Act 1872. So, one has to look towards the Transfer of Property Act and the general clauses of the Act to understand the meaning of immovable property. Immovable property includes land, benefits arising out of land, and things attached to earth or permanently fastened to anything attached to the earth. Right-of-ways, ferries, buildings, fisheries, hereditary allowances or any other benefits to arise out of land are included within the definition of immovable property. Standing timber, growing crops or grass, however, do not come within the purview of immovable property. Immovable property under Code of Civil Procedure 1908. A person who is entitled to recover possession of specific immovable property may institute a suit and, after obtaining a decree, he can take possession of the property in the manner provided by the Code of Civil Procedure 1908. Now, moving to another topic, Suits by persons dispossessed of immovable property under Section 6 of the Specific Relief Act 1963. Law recognizes the sanctity of possession of immovable property and expects that no one having possession will be dispossessed without his consent and otherwise than in the due course of law. Accordingly, this section provides that, first, if any person is dispossessed without his consent of immovable property otherwise than in due course of law, he or any person claiming through him may, by suit, recover possession thereof, notwithstanding any other title that may be set up in such suit. Second, no suit under this section shall be brought after the expiry of 6 months from the date of dispossession or against the government. Third, no appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree be allowed. Fourth, nothing in this section shall bar any person from suing to establish his title to such property and to recover possession thereof. This section is based on the premise that disputed rights are to be decided by due process of law and not otherwise, and therefore peaceful possession should be protected and as such possession cannot be disturbed. Section 6 can be availed by the plaintiff if he or she proves that, first, if the person was in the judicial possession of the immovable property in dispute. Second, if the person had been dispossessed without his consent and otherwise than in due course of law. And third, if the person had filed the suit within 6 months of dispossession. For example, in the case of A.F. Khan versus Mahinder Kumar Jugal Kishore Gupta, the Bombay Court emphasized the point that in a suit for possession under Section 6 of the Specific Relief Act, it is not necessary to consider the nature of the title of parties. What are necessary to be considered is who was in possession of the suit property and whether that person had been dispossessed without following the due course of law. This section has no application if the plaintiff has parted with the possession willingly, with her or his free consent, or he or she has been dispossessed following the due course of law. Now, what juridical possession refers to? For the purpose of Section 6, possession means juridical possession. Juridical possession can be generally understood as legal possession in a more impressive form. The possession may exist with or without actual possession and also with or without a rightful origin. For example, if a tenant is allowed to continue on a property even after expiry of the term, and the owner sleeps on his rights and makes no efforts to remove him, the tenant's possession can be termed as juridical possession, though not lawful possession. For example, in the case of Rame Gowda versus M. Varadappa Naidu, the Supreme Court held that a person who is in settled possession creates such a right that even the rightful owner may recover only by taking recourse to a court of law. The settled possession even of a trespasser may be protected under Section 6. Similarly, in the case of Ajay Kumar versus Chanchal Devi, the Himachal court held that a trespasser who is in settled possession can regain his possession from any person other than the owner who dispossessed him. Now, moving to another important topic, recovery of specific movable property under Section 7 of the Specific Relief Act 1963. The Section 7 states that a person entitled to the possession of specific movable property may recover it in the manner provided by the Code of Civil Procedure 1908. Explanation 1. A trustee may sue under this section for the possession of movable property to the beneficial interest in which the person for whom he is trustee is entitled. Explanation 2. A special or temporary right to the present possession of movable property is sufficient to support a suit under this section. Entitlement to possession. Only a person entitled to possession of a specific movable property has the right to recover the possession of the same in a manner provided by the Civil Procedure Code. This means that when a specific movable property is in possession of someone other than the person entitled thereto, the person with entitlement can file a suit against the person holding the property without entitlement. Entitlement does not mean ownership. It is not necessary that a person entitled to possess the goods should be the owner of those goods. A person who is entitled to possess the goods as a trustee or agent or as bailee is also entitled to recover the same under Section 7 of this Act. It is worth mentioning here that Section 7 can be availed by the plaintiff only as long as he remains entitled to possess the goods. If the right of the plaintiff to possess the goods has expired, the remedy under Section 7 cannot be invoked. For example, State of Gujarat versus Biharilal. In this case, there was an agreement between Biharilal and the occupants of land, authorizing Biharilal to cut and remove trees standing on certain land for a period of 2 years. The forest authorities did not grant permission to cut the trees and the period expired. There was no fresh agreement between the parties, nor was the period of authority in favor of Biharilal extended. Biharilal filed a suit for declaration of his right to cut and remove the trees and also for the necessary permission to do the needful. It was held that since the right in respect of the trees had already expired, the suit filed by Biharilal could not be decreed. Now let's learn about recovery of possession of the property in a manner prescribed by the Code of Civil Procedure. The possession of the property can be recovered by filing a suit as prescribed by the Code of Civil Procedure 1908. The plaintiff should contain particulars in Form 32, Schedule 1, Appendix A of the Civil Procedure Code. The decree for delivery of possession of specific movable property shall be passed in accordance with Order 20, Rule 10 of the Civil Procedure Code. The decree for delivery of specific movable property shall state the amount of money to be paid as an alternative if the delivery cannot be had. The provision may be explained through the following illustrations to Section 10, Specific Relief Act 1877, which corresponded to the present Section 7 of the 1963 Act. The illustrations, though omitted by the 1963 Act, sufficiently illustrate Section 7. Illustrations. A bequeaths land to B for his life, with remainder to C. A dies, B enters on the land, but C, without B's consent, obtains possession of the title deeds. B may recover them from C. A pledges certain jewels to B to secure a loan. B dispossesses of them before he is entitled to do so. A, without having paid or tendered the amount of the loan, sues B for possession of the jewels. The suit should be dismissed as A is not entitled to their possession, whatever right he may have to secure their safe custody. A receives a letter addressed to him by B. B gets back the letter without A's consent. A has such a property therein as entitles him to recover it from B. A deposits books and papers for safe custody with B. B loses them and C finds them, but refuses to deliver them to B when demanded. B may recover them from C, subject to C's right, if any, under Section 168 of the Indian Contract Act 1872. A warehouse keeper is charged with the delivery of certain goods to Z, which B takes out of A's possession. A may sue B for the goods. Now let's discuss recovery of possession of goods under bailments. If the bailee who was in possession of the goods is dispossessed of the same, the suit for recovery of possession may be brought either by the bailer or the bailee against the third person interfering with the possession. Explanation 1 to Section 7, Specific Relief Act 1963 states that an action for recovery of movable property can be maintained by a trustee to the beneficial interest in which the person for whom he is the trustee is entitled. All the persons beneficially interested are represented by the trustee when he initiates an action, so no beneficiary need to be added individually. According to Explanation 2 to Section 7, Specific Relief Act 1963, a suit under this section is supported sufficiently by proof of a special or temporary right to the present possession of movable property. These rights may arise from lien, pawn or bailment, and may also arise through the finding of lost goods, unauthorized pledge, etc. Now, moving to the another topic of this lecture, liability to deliver possession to person entitled under Section 8 of the Specific Relief Act 1963. When a person is in possession or control of certain movable property, but he is not the owner thereof, he may be compelled to specifically deliver the same to a person who is entitled to the immediate possession of such property in the circumstances mentioned in Section 8. Section 8 reads as under: any person having the possession or control of a particular article of movable property of which he is not the owner may be compelled specifically to deliver it to the person entitled to its immediate possession in any of the following cases. First, when the thing claimed is held by the defendant as the agent or trustee of the plaintiff. Second, when compensation in money would not afford the plaintiff adequate relief for the loss of the thing claimed. Third, when it would be extremely difficult to ascertain the actual damage caused by its loss. Fourth, when the possession of the thing claimed has been wrongfully transferred from the plaintiff. Explanation: unless and until the contrary is proved, the court shall, in respect of any article of movable property claimed under Clause B or Clause C of Section 8, presume: first, that compensation in money would not afford the plaintiff adequate relief for the loss of the thing claimed, or as the case may be. Second, that it would be extremely difficult to ascertain the actual damage caused by its loss. Essentials of Section 8. First, the defendant should be in possession or control of a particular article. Second, such article should be movable property rather than immovable property. Third, the defendant should not be the owner of such article. And fourth, the plaintiff should be entitled to the immediate possession of such article. Now, moving to the last topic of this lecture, circumstances when the defendant is bound to deliver the possession. In Khizakumpurat versus Thanikuziel, there was oral and documentary evidence that the plaintiff was the owner of certain scheduled items and the defendants had trespassed into those items. The plaintiff was held entitled to recover those items from the defendants or compensation as well. To conclude, we can say that the Specific Relief Act 1963 is an act to define and amend the law relating to certain kinds of specific relief. The Act is not exhaustive and certain specific remedies can be granted under other statutes also. The Act is based on the rules and practice of the English law in relation to the doctrine of specific performance. So, even though the rights and liabilities of concerned parties and the powers of courts in India in the matter of granting specific relief are governed by the Specific Relief Act, yet, as the Act has been founded on English law, wherever the Act does not deal specifically with any matter, it is permissible to refer to English law. However, if there is an express divergence, then the Act will be strictly adhered to, whatever be the English law. Dear learners, with this we conclude this very important topic of today. Hope you enjoyed the lesson. For now, it's time to say goodbye. Stay blessed.